The Supreme Court is now in session. The Honorable Robert J. Torres, Associate Justice presiding.
Would the clerk please call the case?
This is Supreme Court case number CVA20-008, Joaquin v. Leon-Guerrero, individually and as a taxpayer, plaintiff appellant versus Government of Guam, Department of Administration, and Edward Byrne in his capacity as director, defendants appellants. Appearing for the plaintiff appellant is Attorney Braddock J. Huseman. Appearing for the defendants appellees is Attorney Jordan Lawrence Paloon. The panel consists of Associate Justice Robert J. Torres, Associate Justice Catherine A. Merriman, and Justice Pro Tem John A. Manglona. Attorney Huseman reserves 10 minutes.
Thank you, Madam Clerk. Attorney Huseman, you may proceed.
Good morning, Your Honors. My name is Braddock J. Huseman. I represent Mr. Leon-Guerrero. May it please the court. This case began as a simple taxpayer case and has changed into something quite different. Now it is a case that involves this court's jurisdiction, standing, and even the separation of powers. The Superior Court of Guam dismissed Mr. Leon-Guerrero's taxpayer suit because he lacked a sufficiently concrete injury to satisfy the injury requirements found in the Article 3 of the United States Constitution. The Superior Court came to that decision because of this court's opinion in what the briefing papers refer to as the airport case, In Re AB Wonpat International Airport Authority, a 2-year-old case. The Superior Court interpreted a few paragraphs of dicta within the airport case to conclude that in all cases in Guam, courts require a federal Article 3 standing analysis, particularly as it pertains to injuries. The Superior Court's interpretation, however, is incorrect. The U.S. Constitution does not mandate Article 3 requirements on the island of Guam, and neither does the Organic Act. In fact, the requirement of an Article 3 injury in fact upends literally decades of case law on Guam. Worse, the requirement of an Article 3 injury in fact in all cases as an irreducible minimum jeopardizes a host of Guam statutes, as well as this court's own original jurisdiction and several opinions rendered thereunder. Mr. Leon-Guerrero asked that this court reverse the Superior Court's decision, that it harmonize its case law, and that it remand the case to the Superior Court for further proceedings. With my time today, I'd like to discuss 3 main points. First, there is no irreducible minimum of a case or controversy requirement on Guam. Second is that the Superior Court erred in its interpretation of the airport case. And finally, that if the Superior Court's decision is allowed to stand, if this court does not harmonize its case law, there are catastrophic implications for jurisprudence on Guam. I'd like to discuss my first issue today, that Guam has no irreducible minimum case or controversy requirement. The powers of Guam's government and the limits on those powers are found in 2 documents, the United States Constitution and the Organic Act. And I'm going to refer to those today as the founding documents. And those founding documents set up a familiar system of government, a tripartite system where the legislature writes the laws, the executive enforces them, and the judiciary interprets them. But within those founding documents are restrictions on each of those branches of government, as well as grants of power. As an example that I think is particularly germane in this case today, is that federal courts are limited in their jurisdiction by Article 3 of the United States Constitution. It requires a case or controversy. And a case or controversy is an irreducible minimum in the federal system because it is in the United States Constitution. And so a case or controversy has been interpreted to mean that a case or controversy requires an actual plaintiff who has been injured by a defendant, and that the court can actually redress that injury. And within that sentence are several jurisdictional ideas. One is standing, a plaintiff who has been injured. One is rightness. Has that injury occurred, or is it too speculative to be? The court's redressability, mootness, is an issue moot. And the shorthand we have for all those terms is justiciability. And justiciability, because it is a shorthand for case or controversy, is found. It's an irreducible minimum contained in Article 3.
Now, let me
Guam court.
ask you this, though. I mean, clearly, I think even in Beneventi v. Titano, we acknowledge that the Organic Act provides no express case or controversy requirement. At least textually, there's not a case or controversy requirement in the Organic Act that's comparable to Article 3. And in fact, the Attorney General points out and tries to equate causes of action or causes to case or controversy. But isn't there another source that could be looked to for imposition of the court's minimum standing requirement? I mean, if the legislature can wholesale, expand, modify, or amend our jurisdiction or our standing requirements, doesn't that make the judicial branch subservient to the legislature and violate separation of powers?
Okay, well, I think what you're asking is there a way for the, and I think I understand your question. Is there a structural argument for a case or controversy within the Organic Act? Is that?
Yeah, relying
Okay.
on separation of powers, or even statutorily. You talked about justiciability, and 7 GCA 3107, which provides that the Supreme Court has authority to review all justiciable controversies, could perceive to be an additional source for the case or controversy requirement that has been laid out, or imposition of a minimum standing requirement that was laid out in the airport case.
Sure, Your Honor. Well, and I would say this, that there isn't a separation of powers issue to address that firstly. And the reason there isn't is there are checks and balances. And so if you look to the federal Constitution, there are original grants of jurisdiction, just like there are in the Organic Act, to our local courts. And as far back as Mayberry versus Madison, it's been established that if those requirements are in the founding documents, if the original jurisdiction of the United States Supreme Court is enunciated in Article 3, that Congress can't amend that original jurisdiction. But if you look at Article 3 of the United States Constitution, it does allow for the Congress to manipulate the appellate jurisdiction of the United States Supreme Court. That is explicitly granted. And in the same way, the jurisdiction of Guam courts can be modified by the legislature with some caveats. So the legislature obviously could never go against the Organic Act or the United States Constitution. So in this case, the Organic Act puts some cases solely within the purview of the United States District Court for the District of Guam. And obviously the legislature could not expand the jurisdiction there, but the legislature can and does routinely modify this court's jurisdiction. As an example, this court's original jurisdiction, it removes the case or controversy requirement immediately. If the court looks at the court's own enabling statute under its original jurisdiction, the certified question jurisdiction, the legislature says that these don't qualify as cases or controversies, that these are important issues, and that the legislature and the governor need them settled and cannot wait for a case or controversy to develop. And so in that case, the legislature has explicitly relaxed the requirement of a case or controversy. In a similar way, if you look at the Open Records Act, the legislature has imposed an Article 3 requirement on the open records case, because on Guam, unlike in some jurisdictions, the individual who seeks a open record has to be the one that wrote the letter. So in some jurisdictions in the United States, if I, as an attorney, write a letter for a a client of mine, but don't name the client and demand documents, my client cannot bring the case. In Guam, however, that's the case in Guam. In some cases, in some jurisdictions, they can. It's not a problem. So the Guam legislature has put the requirement of an injury into our Open Records Act. But generally, the legislature is silent on justiciability. And this court is free to use those prudential concerns anytime it wants. And so I don't think that there is a irreducible minimum that can be found in the Constitution, obviously, because it doesn't apply, as this court has said. I don't think the Organic Act can be read to contain such a case or controversy requirement. I don't think there is a separation of powers issues. I think the legislature usually has control over the jurisdiction of the courts they oversee, as long as the pronouncements do not run afoul of the founding documents.
Well, and I think included within that founding doctrine is the inherent judicial power and separation of powers. And and while I appreciate and I think I agree with you, textually there is no case or controversy requirement, I'm not convinced that the court itself, in the exercise of its power under the Organic Act and under separation of powers, can't have a justification for exercise of judicial restraint. And while the legislature has the authority to impart statutory causes of actions and to the extent, the court's jurisdiction, I'm not convinced that it could abrogate the court standing requirements in a way that would run afoul of the separation of powers principles inferred in the Organic Act. But putting that aside for now, I want to focus on the taxpayer standing and under the Taxpayer Enforcement of Good Government Act, taxpayer statute that I wanted to focus on. Clearly in the airport case, the court determined that the legislature could impart a judicially cognizable injury upon a particular cause of action and essentially have a de facto injury that was previously inadequate in law. And if I remember, it specifically focused on the the Open Government Law and the Sunshine Act has two areas where that might be relevant in that case. What about why couldn't the taxpayer statute provide that injury? In fact, why can't we analyze it under that situation? And can we, so that we determine that what the legislature has done here is really just elevated to a legally cognizable injury, what was an injury that might have been inadequate in law and not satisfied the standard that we had set forth in the airport case?
Well, that's a good question. I don't know that there's a way. It certainly isn't Article 3 standing then, correct, Your Honor? It can't be Article 3 standing as a taxpayer because the federal courts are openly hostile to taxpayer actions unless there is a concrete and particularized injury. And so if the legislature can broaden, and I believe it can broaden jurisdiction this way, I think it is within the court's ability to say that injury counts, but that injury is not an Article 3 satisfaction, right? So I think there would still need to be some harmonization of the court's case law with regards to what constitutes an injury and whether you can meet the statutory requirement, because a taxpayer claim will not, absent a particularized injury, pass muster under Article 3. And similarly, the Open Government Act, a violation of the Open Meetings Act here on Guam, will not pass muster. And if you look at the legislative directive in the Open Government Act, is that the people of Guam do not cede sovereignty to the bureaucracy that's entrusted to carry out their business. And
Well,
if an injury is
the
required,
airport case said that the public records and open government laws are common examples of statutes that confer sufficient injury to satisfy the injury in fact component of a constitutional standing analysis. I mean, that's in paragraph 24 of the airport case. And so that was where I was having some difficulty in terms of understanding how you reconcile this idea of elevating these intangible harms to satisfy the injury in fact requirement and granting this statutory right to sue and recognizing that the legislature could do that, with the idea of the other language in the airport case that talked about statutory standing and constitutional standing are separate inquiries and distinctly separate inquiries.
well, I think the airport case, AB1PAT, actually says that they were, but should not be thought of as distinct injuries going forward. And part of and I agree with Your Honor. If Your Honor is saying that the legislature can elevate things to a harm, I have no problem with that. And if that's the way the court wants to harmonize its case, I think that's appropriate. What I am saying is that those harms will not qualify under Article 3 standing. Article 3 is too clumsy of a tool to stop that. And so Mr. Leon-Guerrero, it isn't important to him that how his claim goes forward. It's just important that it goes forward, that the courts recognize that there is an injury there and that he can bring his claim. But I would say, Your Honor, that if the court is willing to say that the legislature can elevate certain harms, then I think that's appropriate. I think that works. But clearly sorry, Your Honor.
That's what the court said in the airport case, that the legislature can broaden it to elevate de facto to the article to concrete injury. But you seem to be asking us to reverse what you, I guess, mentioned as dicta in the airport case. But I don't think it was dicta. It was pretty straightforward. That was the holding in the airport case. But now you're changing your position that we should not overrule the airport case if we can harmonize the injury.
Well, I haven't, with respect, I have not changed my position. I think that the airport case calls for Article 3 standing, and I think that Article 3 standing does not allow for certain types of cases, taxpayer cases inclusive, this court's original jurisdiction inclusive of that. But what I would say is this: I do think it's dicta, and it doesn't matter to me if it's what's important to is that the court get it right. Right. So if I think it's dicta, I think it can be harmonized. I don't think AB1PAT needs to be outright overruled. I put that in the briefing. But I do think that the paragraphs requiring Article 3 standing in Guam are dicta, and this is why I think that. Dicta is as the court knows, a portion of an opinion that isn't necessary to the outcome of that opinion. This court could have assumed that Article 3 standing is required in all cases on Guam without deciding that matter. And once it decided that matter, it was a bridge further than it needed to go. As it is a bridge further than it needed to go, that can be dicta, or that is dicta, I should say. So I take your point, Your Honor. What we're asking for is, at the end of the day, that the Superior Court be overturned so that it recognizes that when the legislature authorizes a cause of action, that absent a contrary command in one of the founding documents, the Organic Act or the U.S. Constitution, that those cases be allowed to go forward. That's what we're asking for today.
Let's focus on the requirements of the taxpayer statute and the compliance with them. The 7103 talks about enjoining someone from the executive branch from expending money without authority, illegally, or contrary to law. And at the time the judge rendered his decision, there was no determination that the law in question was illegal or that there was an improper delegation. And it seems that the action that was being complained of was the legislature's action and not it was the complaint was that the legislature had improperly delegated its authority to a private party, and that and it didn't seem that the complaint was really directed at the actions of the executive branch or what their wrongdoing was. And then the Attorney General points out that it seems to put them in a difficult position of whether complying with the law or whether, just standing still and not complying. And so I want to hear your reasons why the nature of the claim that is advanced is really directed towards the unlawful spending by the executive branch instead of the complaint being with the policy choices of the legislature.
Right. So this isn't about the policy choices of the legislature, Your Honor. This is in California, and we've cited this in our brief, but in California, you can bring taxpayer cases to stop the illegal expenditure of funds, but the illegal expenditure of funds includes the expenditure of funds to implement an unconstitutional law. And in this case, this is an inorganic law. The governor of Guam, under this law, no longer selects the best healthcare insurer. The government of Guam selects from a list provided by a private entity. And that private entity, as alleged, is using its power bestowed upon it to, ask for kickbacks. The question you're asking, Your Honor, is, I think, respectfully, more one of standing and when does my client meet the requirements within the statute? And that's a summary judgment issue. It's not a pleading issue at all. The government always has an extremely easy out on a taxpayer claim, and that is to demonstrate that the complained of actions are legal.
Wasn't that the basis of the judge's dismissal was standing? He said that he didn't have standing. He didn't meet the requirements of the statute. That was
right, but he did, with respect, Your Honor, that we were dismissed for standing, but the standing was due to the fact that we don't have an injury in fact, not that we didn't plead it correctly. And you can go back to, I think it's ER 65, but I'll double check that. It actually, the Superior Court actually stated that this court's opinion supersedes the statute and that my client had to show an individualized injury. And that's why we were dismissed. And so all that's required under the taxpayer statute is to allege an illegal expenditure of funds, which we've done. Director Brin is expending funds to implement an unconstitutional statute, and that is the problem. And Guam has allowed a private entity to take its powers of the government and turn around and use those powers in a way to enrich itself. And so the issue here is one for summary judgment. The government can plead that this is legal. They could demonstrate it's legal. They could show that the private hospital, the public hospital, which has political controls placed upon it and which has to follow Guam law, could do the exact same things that the private hospital did in this case. They didn't do that. And the reason they didn't do it is because it's illegal. I'm sorry.
Now that you mentioned that there's illegal expenditure, is that still happening today? The director of administration is still expending money illegally pursuant to the statute in light of the district court's decision?
I don't have any. I don't have any information on that. I'd have to brief that, Your Honor. I really don't know. But that doesn't go to whether or not my client has pled that would go to mootness and it would require additional briefing. And it doesn't go to whether or not my client sufficiently pled a claim under the Taxpayer Act. It might be changed circumstances by now. I don't think so though, but I'm not sure because and this is the thing, the current healthcare system was procured under this inorganic law. And so any furtherance of that, of the current healthcare plan is an expenditure of funds under an inorganic law. That would be my position. But I think that goes to, that would require additional briefing.
All right, the AG might have the answer.
And then I can see that I've
exceeded
gone over a little
your
bit.
time that you had. I mean, you're eating into your reserve now, I think, Mr. Huseman.
I
mean, if
understand.
you want, you can continue or you can defer the balance of your time.
I will reserve the balance of my time. Thank you, Your Honors.
All right, thank you. Mr. Pauloon?
Good morning, Chief Justice, and may it please the court. My name is Jordan Pauloon, and I represent the government of Guam and the Department of Administration, including Director Edward Byrne in his official capacity in this case. We ask this court to affirm the ruling of the court below for primarily two reasons. First, the reason decided by the trial court that we agree with is that the Enforcement of Proper Government Spending Act inorganically removes the standing requirement, particularly the requirement of an injury in fact. And then second, the Enforcement of Proper Government Spending Act itself does not authorize taxpayer suits to challenge the organicity of statutes. It is directed towards challenging exclusively executive action and not legislative acts. The biggest fundamental error in this case, or in Leon-Guerrero's case, is that he does not have any particularized or personalized injury that actually impacts him in this instance.
So you think that the taxpayer standing statute has been entirely eviscerated by the airport case?
I don't believe that it's necessarily been entirely eviscerated by the airport case. For example,
why couldn't the standing that's created under the taxpayer lawsuit, Enforcement of Good Government Spending Act or Proper Government Spending Act, provide or elevate and impart a judicially cognizable injury, where it otherwise might have been inadequate previously?
So the legislature can certainly recognize individual rights that were commonly seen in common law as inadequate to bring an action in court. However, in bringing an action in court, you still have to show that you have been injured as a result of whatever it is, that not just that there's a statutory violation, but that you've been injured. And I think this court's opinion in the airport case actually demonstrates that interplay very well. Historically, at common law, there was not a right to access certain documents or records held by government agencies. However, the government of Guam and other governments throughout the United States have adopted things such as the Open Government Law and Sunshine Act request to give people that right. But in order to actually bring a cause of action, you have to show that you had personally made a request for that information and that information was withheld from you. And so you have been injured in that particular context by the actual withholding of the information that you were otherwise entitled to only under the statute. And so you still have to show the particularized harm there. In this particular instance, there are parties that may be able to show a particularized harm or allegation of harm from the statute in question, such as other insurance companies that are allegedly iced out of the market as a result of this law. However, plaintiff Leon-Guerrero does not have any particularized harm directed towards him in any way. He hasn't alleged that he is covered by this law, that he's involved in the insurance market, that he wants to bid on this. He's alleged no other standing than merely he's a taxpayer which is insufficient under the airport case. And so I
Would
think
a retiree or a current Guam employee have standing under this provision?
I have not studied that in any particular detail to actually applying one way or the other, but I think that at least alleges something that you could then get into the sufficiency of that harm and whether it's an actual harm or not. Merely a statutory violation alone, even if you're in the zone of interest of the statute, won't necessarily inflict an injury upon you, but there may be questions for somebody impacted by the law that may have standing in that particular instance. They would still have to show a particularized injury, but at least they're getting a little bit closer.
Now, what about the source of establishing the irreducible minimum that was set forth in the airport? Because there really wasn't much discussion other than the reference to Article 3 of the authority for imposing these minimum standing requirements. And clearly the text of the Organic Act or the Omnibus Territories Act either doesn't refer to an injury requirement and doesn't have that case or controversy language. It has causes, as you pointed out. And I know you tried to bootstrap the limited jurisdiction of the district court and the interplay between the local executive and legislative branches as suggesting that maybe that was why Congress wanted to impose the same requirements. But I mean, clearly Congress knows how to impose those requirements if it wanted to impose those requirements.
Certainly, and I don't suggest that any one of those facts, either the text structure or history alone necessarily are this smoking gun of interpretation, but I think when taken together, they are suggestive of that fact. I think more fundamentally is, yeah, I can see that Congress in adopting the Organic Act did not use the words case or controversy. They used the word causes because we are dealing in Guam, having local courts like in any other territory. You're dealing with things that would by and large fall outside of federal question in a number of circumstances and mimic what is more usually thought of as state law questions. But would still need to be dealt with by some court in the territory. However, causes of action, that term as historically defined in the common law, as recognized in Black's Dictionary and other cases, still requires that a person be injured by something before they show up in court. Otherwise the judiciary just gets into the business of issuing advisory opinions on a whole host of statutes, policy issues, and other things. The judiciary, by its nature and by the long history of separation of powers cases in Guam and standing cases that were recited in the airport case, has recognized that the judiciary still comes in to decide like actual controversies and cases where people are actually harmed. Mr. Huseman suggests things like the certified question as something that would be open to attack here too. However, if you look at all of the certified question cases that have ever been decided by the Guam Supreme Court, they come in under a context of a real life dispute between two separate branches of the government. And there's a long history of case law related to standing and institutional injuries, such as a legislative injury or injury to an executive office. There's institutional injuries that can be litigated, and that's just been, and this court has been given original jurisdiction over those types of causes of action. But we have never removed a standing requirement for somebody to come in and challenge the organicity of a legislative act. And so you actually have to show, we have a long history of having to actually show that you've been injured by the complained of conduct. And I think if you take a look at the airport case itself, paragraph 18, this court recites not every case, but a bunch of cases in the long history of the standing requirement where you actually have to have an injury in fact. And what Mr. Leon-Guerrero was attempting to do is come in and not allege any injury, just complain about what the legislature's done. The proper remedy for that type of thing is through the political and legislative processes. He can petition the legislature, he can vote for legislative officers, he could run for office, a whole bunch of things. That's how the political process works. There is a political check on these types of decisions as well, if he feels like the government isn't making decisions that he feels are best. However, it doesn't give him, just because he disagrees with the law, doesn't give him the injury necessary to come to court and have the court then, absent some injury, second guess a co-equal branch of government, in this case, the legislature. The judiciary comes in and resolves real causes of action where people have really been injured. It's not to litigate policy choices absent some sort of legislative policy choices, absent some sort of injury. And I think this also
Mr.
Yes.
Pelham, now that we know the statute is inorganic or unconstitutional, should we send it back to the Superior Court to see if there is an actual injury? That issue seems to have gone by the wayside here. So has Mr. Leon-Guerrero indicated that there is illegal expenditure going on?
So to the extent that there may be an illegal expenditure, still does not give Mr. Leon-Guerrero standing. That may go to the sufficiency of his cause of action under a failure to state a claim analysis, but it doesn't mean that he has a particularized or personalized injury in fact in this case. I do think that the district court's decision that's kind of the elephant in the room in this case, it may come into play in a jurisdictional question of mootness, but I don't think it comes into on the jurisdictional question of standing alone, because irrespective of what the issue is here, Mr. Leon-Guerrero does not have any personal interest in the outcome of this litigation. He's complaining about this as a matter of policy, which should be accounted for through the political and legislative checks and processes.
So if the legislature by statute, you pointed out, and in the airport case, we recognize that the open government law and the record request law were two examples where they could impart a judicially cognizable injury, where to establish an injury in fact. So couldn't they and couldn't the taxpayer statute also establish that injury in fact by having there be an illegal expenditure of money, as Justice Merriman indicated, and that can be then traced to the challenge action that was taken by the defendant, which was to pay out the money based on this illegal law, and the favorable decision can remedy that injury?
I think that confuses the legislative impartment of a new right that was historically not recognized in common law with the injury in fact requirement. They're not perfectly the same, because the difference between the Sunshine Act and the Open Government Law, which provided actual right to access that must be violated. The key component of the legislative action there is providing the right, and then the standing occurs when that right is violated. The enforcement of a proper government spending act confers no new right on an individual. It does not provide a right to information, does not provide a right to access or attend certain government meetings. What it does is just say, you can sue over this. You don't have any new rights beyond what there is. It's just go and sue to enjoin, and also importantly, hold these individuals in some cases personally liable for the unlawful expenditures, which actually goes into the second point of my argument as well, that this is not really the type of suit that is authorized under the Enforcement of Proper Government Spending Act either. It's it's really it's really intended toward ferreting out executive misdeeds, not legislative policy choices. If you look at the history of the act itself, too, it was adopted at a time when the Attorney General was still appointed by the governor, so there's a principal agent problem and actually rooting out unlawful, like corrupt expenditures. And so it was an attempt at that point in time to remedy that principal agent problem, because let's say a government official appropriates money from the government coffers, just writes a check to themselves for whatever reason and takes that money. There's not going to be anyone besides the government itself that's going to have standing to challenge that type of conduct, that type of unlawful spending or appropriation, because it rises to a level of, would probably rise to a level of criminality and would rise to a level of unlawfulness, certainly. And the Attorney General's office would be the only ones that would be able to bring that particular type of suit. And so at the time when there was a principal agent problem between the governor and the Attorney General, they tried to seek to remedy that a little bit, to root out that real corruption here, not relitigate policy choices, but rein in executive conduct that was acting in contravention of explicit statements by the legislature. The legislature did not open itself up to be policed by taxpayers. It opened up exclusively executive action to be targeted by these types of suits. So even if we're going to find some narrow exception here, the Enforcement of Proper Government Spending Act doesn't cover this type of lawsuit where they're trying to litigate the organicity and policy choices of the legislature. The legislature didn't and probably wouldn't have opened their own acts up to challenges through a taxpayer lawsuit. What we're really concerned with is, instances where we have a clear budget bill. It might say even, you cannot spend any money on this program, and then a government official continues to spend money on that program in direct contravention of an appropriations bill, or they're stealing money. That type of direct contradiction from the a legislative act is really what's being targeted here, not the ability to challenge the organicity and relitigate policy preferences.
But getting back to Justice Merriman's question, now that there's been a determination that it's been an improper delegation and therefore illegal, and if the money continues to be expended, isn't that then directly what you've indicated, that it's akin to, there's a specific command that the money not be spent or not be appropriated, and the government official ignores that?
And so I think that comes at the time of the, I think that analysis may come at an earlier time in the process, and I don't think that there's any evidence or allegation that was necessarily ignored, nor, and would go to an analysis of mootness potentially. It is important to realize, though, that while the district court has made that particular finding, we are still awaiting final judgment in that case, so it doesn't have the preclusive effect that would necessarily make this case moot at this particular time. We will have to wait for the final judgment. I'm not suggesting that time won't come, but I am suggesting that it's a little bit premature to engage in such a mootness or send back challenge right now. It might come forth in the next several weeks, but right at this moment, that is a little bit premature because there is still an issue of finality of that decision. That said, that still doesn't necessarily give Mr. Leon-Guerrero standing himself. While Justice Merriman's question does relate to an important question of justiciability and jurisdiction related to mootness, that doesn't bring Leon-Guerrero in under the other component of jurisdiction, which is standing, because he does not have any injury in fact.
Mr. Pellew, did the legislature say that a taxpayer is injured if money is spent illegally?
No, they did. Let me let me, I can pull up the statute here. I do not believe that that's precisely what was stated in the statute itself, was that there's an injury here. All they say is that a resident shall have standing to sue the government or any other agency for the purpose of enjoining these unlawful expenditures. They do not raise this to a level of conferring an actual right on taxpayers or any other individual. They just say you have standing to sue. It's this broad pronouncement that just go in and sue, but they do not confer a particular right to have all of your tax dollars paid only towards lawful programs, for example. They just say go in and sue if somebody in the executive is violating what we've told them to spend money on.
What if the legislature were to pass a law that is from Supreme Court precedent clearly unconstitutional, maybe to give money to a church? Would a taxpayer then have standing? Because even though the law hasn't been determined to be unconstitutional, clearly it's violates the Organic Act.
If you're coming within the religion context, however, such as the establishment clause that would fall on, that a circumstance like that would fall under, even if we're dealing with an Article 3 standing requirement, there would be standing in those cases because there is a particularized, the United States Supreme Court has found a particularized injury in those things because you were essentially being forced to engage in religious activity. And so, some courts view it as, some federal courts view that as a exception to the taxpayer rule, the bar against taxpayer standing because of an exception given by the First Amendment, or you can view it as an actual injury in fact of having to participate in religious activity and stand by and be, depending on the nature of the harm, either offended by a religious thing that's been constructed, such as a cross on the side of a highway or something else. But if we're dealing with religious things, even Article 3 would confer standing for those types of suits.
The enforcement of proper government spending also has a separate provision that specifically gives the taxpayer or the resident who has the authority to seek a personal judgment to have standing to pursue the execution and collection of the judgment on behalf of the government of Guam. Do you think that's permissible? Does that create the injury in fact? Go ahead and finish. No, that you assert is missing this particularized injury?
I don't think that even rises to that level because the collection doesn't even provide any money or anything to the taxpayer themselves. It's on behalf of the government of Guam. The injury still here is to the government, not to the individual taxpayer.
So you think that the language in 7109 that gives the right, and in fact uses the word shall have standing to pursue execution and collection on the judgment is inorganic or exceeds the powers that the legislature has to provide that standing to a taxpayer?
Now, under our present discussion, yes. The other form that we haven't necessarily discussed per se are such suits as key tam actions, for example, which would allow somebody in like the taxing context to whistleblow on somebody and then collect on behalf of the government. But those suits are also pursued in the name of the government against a particular offending individual. But I also think that given the nature of this type of suit that Mr. Leon-Guerrero is pursuing, this idea of personal liability is what makes his policy challenges here that much more disturbing. In this case, he does only pursue the injunctive relief, I think, as Mr. Huseman points out in his brief, but that's not textually the only remedy he can seek. There is this issue of personal liability. And so if you have some agency director, such as Mr. Byrne, presented with this thing where the legislature has said, we want you to procure a health insurance contract on these terms. Nothing about it is like, even if nothing about it screams on its face that this is some religious violation or other thing, but he has this direct command from the legislature saying, do this. So now he's faced with a Hobbesian choice of either executing and doing his legally required job of procuring his health insurance contract, but just in the event that he may be wrong sometime in the future, that some court may believe that this is unconstitutional or inorganic, he stands to face a personal judgment for the amount of this health insurance contract. And that's just that's an outstanding implication from a suit that's supposed to actually weed out real corruption, not place government officials in this Hobbesian choice of either following the law or not, just because they're afraid of a personal judgment based on what are really complex and technical legal questions about organicity and constitutionality. And so I think that goes back to really where this fundamental error is in this case, and that's Mr. Leon-Guerrero does not have any particular injury, nor does the statute authorize this type of suit for relief on organicity challenges. It's really targeted at actual unlawful spending. You hold up, if there is going to even be a claim here, to state a claim under this, you really need to hold up an act of the legislature and show either that here's an authorization that they're violating, or if it's something that they're spending without an appropriation, go show that there's no appropriation and hold up the executive spending that's done without an appropriation. It's that type of illegal spending where you're comparing executive conduct to actions of the Guam legislature that is really being targeted here. And that's what actually the Enforcement of Proper Government Spending Act, both on its text and its legislative intent and history, is really targeted at and actually means. It doesn't mean come in and relitigate a legislative action every time you disagree with the legislative choice. Those types of choices should be handled through the political processes, not through an action in court by someone who has no personal interest in the outcome of that litigation.
Does the injury have to be capable of calculation? This seems to me the kind of factual scenario where it might be extremely difficult to figure out how much money this costs the government in any legal sense. So is there also a requirement that the injury be particular?
I think it needs to be particularized. We don't necessarily need perfection in calculating damages and judgments. Otherwise, we'd probably never be able to resolve any case, because certain aspects are a little bit of take a little bit of educated guessing of sorts. But at the same time, you do need some sort of real interest in it. And I actually think that the U.S. Supreme Court, in a case that I'm now just that I'm thinking about, can't recall the name of the time I had, has found that nominal damages, for example, would be sufficient to pursue a case. But you actually still have to have an actual right in those particular instances before you have that injury. But at the same time, the Article 3 and the federal courts, including the United States Supreme Court, has repeatedly made it clear that you still have to have a personal stake, and you actually personally have to be injured. And Guam, through its long history of cases, through the language and history of the Organic Act, has that same requirement that you have to be injured before you appeal to the courts for relief.
Counsel, what is your response to Leon-Guerrero's Virgin Islands case. This is the Donis Burke, I think, Donis Stort case.
Yes.
Yeah, it takes a different position from the Guam Supreme Court in the airport case. That they're on case and controversy or case or controversy. What is your position on that? And it seems that the Organic Act of the Virgin Islands and Guam, the Guam provisions are very similar.
The original adoption of the provisions between Guam and the Virgin Islands were similar. Some of the amendments that have occurred since then, such as the independent election of the Attorney General's Act for us, the transfer of powers to our local Supreme Court, have not occurred in tandem in the same way. That said, as well, just as a matter of jurisprudential concern, there's no special justification or reason to overturn Guam precedent based off of precedent from the Virgin Islands. While it may have some instructive authority here in our interpretive measures, that case has been around since long before Guam's standing jurisprudence developed as recognized by the airport case. And there's no special justification now for departing from that simply because the Virgin Islands have decided it before we had decided that as well. And so it does not offer a special justification. We should follow our own precedent and not that from the Virgin Islands.
The Ninth Circuit also seemed to have reached the same conclusion in the island equipment case.
Yes. And so the Ninth Circuit has suggested that before as well, but we do have our own judicial autonomy and jurisprudence here that there is, even if this court could have reached a different outcome at an earlier stage of its jurisprudence, there has to be a special justification for deviating from that particular case at issue. And I think that this also goes to the fundamental problem that Leon-Guerrero has advanced on appeal, is that he has not proven a special justification for his main ask in this case, which is to overrule a well-reasoned decision of this court based on long-standing prior history of case law. And so for those reasons, we ask this court to affirm the ruling of the court below.
Thank you, Mr. Paloon. You have your time's up. And so how much time does Mr. Huseman have remaining? Courtroom clerk, can you just confirm? Is that 4 minutes?
Yes, Your Honor.
All right, 4 minutes remaining, Mr. Huseman, to wrap up.
All right, Your Honor. Thank you. I think my friend from the government said the quiet part out loud, which is the government wants to impose Article 3 standing in all cases on Guam. And I think that's a really important point to bring out here. If this court imposes Article 3, it is the only territory to do so by claiming the Organic Act says it should. Virgin Islands rejects it. The CNMI rejects it. Up until, well, for 50 years, this court has rejected it, and its predecessors have rejected it. And as far as the reason the government wants,
but there have been
Article
other
3 is
courts that have determined, notwithstanding the fact that their constitution has no case or controversy requirement, to have made a determination that comparable case or controversy and a minimum that is akin to the federal case or controversy statute is appropriate. And didn't they find their source for imposition of that in separation of powers under their constitution?
Not necessarily, Your Honor. So the government cites Kentucky as one of those jurisdictions. And if you read the Kentucky Constitution, it says that the Kentucky courts have jurisdiction over all justiciable causes. It uses the term causes, but it modifies the term causes with justiciability, which goes back to the reason why the government's theory isn't correct. because justiciability modifies the cause of action, and they are not interchangeable. If they were, the Kentucky Constitution could read justiciable justiciables or causes causes. It doesn't make any sense. And so this isn't, and this
What
is a
about
separation of powers issue.
3107A that talks about justiciable controversies and proceedings?
Sure, Your Honor, and that is your enabling statute as an appeal. I would want to brief that for Your Honor to give you a considered opinion on that, because now we're talking about Guam law and what that means as far as this court's appellate jurisdiction, right? And if this court's appellate jurisdiction is limited to justiciable claims, but certainly that's Guam law, and it isn't the Organic Act. And I want to be really clear about this. What the government is asking for this court to do is to impose a term that does not exist in the Organic Act. That isn't just a separation of powers issue, right? So the Organic Act says that the courts of Guam shall hear as the law of Guam provides. That's a clear grant of power to the legislature. And what the government is asking for this court to do is not only ignore that grant, but insert other language into the Organic Act. And as we know, the Organic Act isn't drafted by Guam. It's drafted by the US Congress. So at some level, they're asking this court to act as a super legislature on par, not now on par with the government of Guam and its two other branches, but what it says goes. And there isn't a limiting principle here either. Is it just on jurisdiction, or is every opinion this court issues a founding document? Because that is what the government is asking for. And I think it is a separation of powers issue, but it goes towards Mr. Leon-Guerrero's side, not the government side. I want to make a quick point about Article 3 injuries and the Open Government Act, because this is different than the Open Records Act. As I discussed earlier today, the legislature put in an injury requirement in the Open Records Act, in the Sunshine Act. In the Open Government Act, there is no injury requirement. The people of Guam don't have to show up to a board or a meeting to determine whether the government carried out its duties. And the express intent of the law is to not force the people of Guam to run around to all the different meetings to make sure the government is doing what it's supposed to do. The burden is on the government to carry out open meetings and to do its job right. And the penalty for the government not doing its job right is that anyone can bring a claim to void those actions. Article 3 standing is incompatible. Concrete injuries are incompatible with the open records or with the open government law here, just like they're incompatible with the taxpayer claim, but just like they're incompatible with this court's original jurisdiction from the legislature. If Governor Leon-Guerrero can bring a certified question that is asking this court for an advisory opinion, and for at least 2 decades, every time this court issues an advisory opinion, it admits that it's an advisory opinion and that there's no actual standing, and the case isn't even ripe yet. But if a Governor Leon-Guerrero can bring that claim, then Mr. Leon-Guerrero can bring that claim. If Mr. Leon-Guerrero cannot bring his taxpayer claim, Governor Leon-Guerrero cannot have a certified question either. That is the problem with importing Article 3 into Guam. It is too blunt an instrument. It just is. And I have very few seconds left, but what I would like to discuss is this idea that this is a policy choice or a dispute on policy, and that could not be further from the truth. The policy arguments have all come from the government today. It's not fair to have a law that allows local Guam government officials to be attacked personally. Well, that's a policy argument. The policy has already been dictated by the legislature. They said it's okay. I don't know if that's good policy. I don't know if it's bad policy, but it is, of course, the policy. And individuals have standing to bring these claims. This is not a policy challenge. What Mr. Leon-Guerrero wants to do is to remove the procurement authority from the private hospital where it does not belong and place it back with the government where it does. And that injury is no different than an open records request, an open meetings request. What Mr. Leon-Guerrero is asking for, he has a right to have the government expend money legally. The government has illegally delegated authority to a private entity, driving up costs for all of Guam, but expending tax money under that regime is incorrect. And he's asking for that money to stop being spent. This isn't a policy dispute. A policy dispute is an easy resolution. All the government has to do is file a motion to dismiss and say what it did was legal. It didn't do that. It said there was nothing Mr. Leon-Guerrero could do about it. And they're here today saying the same thing. Let us act illegally. It's okay. And it isn't okay. And what we're asking for is this court to reverse the Superior Court, remand the case for further proceedings, and to harmonize its case law to recognize that the legislature can impart injuries, whether that is whether that requires a reversal of AB WAMPAT, I don't think so, but I think those cases can be harmonized. I think the court does need to recognize that the legislature can elevate certain harms to give individual standing. And I'm over my time. If there's no other questions, I'll conclude.
All right. Thank you, Mr. Huseman. Thank you, Mr. Pauloon. The court will take the matter under advisement and will issue a written opinion and will now stand adjourned. Thank you very much.